Magandang araw, mga kababayan, mga ka-DDS. Disclaimer lang ang pag-repost at pag-replay ko sa video content na ito ay propagation purposes para sa dagdag kaalaman ng ating mga viewers. Credit to the rightful owner, Attorney Nel Abayon. Napakahusay, napakalinis, madaling maintindihan, very specific ang kanyang mga explanation. May reference, may basis sa madaling salita, based upon proven security principles according to the language of the law. Lalong-lalong na pagkarapatang pangtao ang pag-uusapan. Panoorin natin, mga kababayan.
Okay, so tuloy po tayo sa discussion natin tungkol dun sa decision ng ICC Pretrial Chamber rejecting the Duterte's jurisdiction challenge. Okay, so this is the second part po where I will be explaining the legal technicalities or yung mga komplikadong bagay po tungkol sa mga kaso. So kung gusto po nyo yung more on general conversation, general questions lang kung ano yung mga pwedeng gawin ni Fprrd pa sa kaso niya, nandun po yun sa first video. But for this one po, I will be giving a summary on the technical legalities or yung mga rason po ng ICC sa pag-reject nila dito sa defense ni Fprrd. Okay? So good evening po ulit my fellow taong bayan, and to start things off po, ang gagawin muna natin is we will verify our document to determine its authenticity. Okay, so ginagawa ko po ito palagi itong authentication para lang makaiwas tayo sa mga fake news allegations dito sa channel po natin. Okay, so anyway po, this is a document from the ICC Pretrial Chamber. Again, if you want to get a copy of the latest development po sa kaso ng Fprrd, i-search nyo lang po sa Google ICC case Duterte and then lalabas po agad yan. Well, sa akin po, sa Google ko, yun yung unang lumalabas agad yung part po ng ICC website tungkol sa case ni Fprrd. And then sa may right side po niyan, may makikita kayong court records. I-click nyo lang po yung court records and then lalabas po doon yung pinaka-latest. And at present po, ito yung latest document, which is the Pretrial Chamber 1, the decision on the defense challenge to the jurisdiction of the court. Okay, so kung makita po nyo, the ICC logo is in the middle, and then ito po yung ICC case number ni Fprrd, and then International Criminal Court here sa left, original English. Again, the case number, the date, October 23, 2025 lang po to. Ngayon, 26 na, medyo na late na nga po tayo actually. And then, of course, yung header nung pretrial chamber, chamber 1 pa rin po tayo. And then, the same judges po yan, presiding Judge Motok, Judge Alapinigansu, and Judge Flores Liera. Okay? And then, this one po, kung makita natin, meron na naman po yung procedural history or procedural background po sa nangyari so far kay Fprrd or sa case po ni Fprrd sa ICC. Okay? And dito naman po, yung pinaka-important lang na iti-take note natin na dates talaga is this one, itong February 8, 2018, which is the date po kung kailan yung prosecutor nag-open ng preliminary examination sa Philippines. Okay? And then yung next po na kailangan nating i-take note naman dito is on March 17, 2018, yung Philippines ngayon nag-deposit na sila ng written notification of withdrawal from the statute. So tatandaan po natin sa Rome Statute kasi kung magwi-withdraw po yung bansa, kailangan muna nila niyan mag-deposit ng written notification, and then that will only take effect after a year. Okay, so 1 year after lang po. And then because of that po, ngayon makita natin sa number 4, March 17, 2019, the withdrawal of the Philippines from the statute took effect in accordance with Article 127.1 of the statute. So ito pong statute is the Rome Statute. Ito na yung pinaka-main important dates talaga dito sa discussion or sa reason po ng pretrial chamber ng ICC kung bakit ni-reject nila itong challenge to jurisdiction. Okay? And then ngayon po, punta naman tayo sa defense. Okay? But before we go there po, ita-take note ko lang din pala sa inyo, ipapatake note ko lang din po sa inyo itong another date po, 15 September 2021, yung actual investigation kung saan nagpaalam po yung prosecutor, ito on 24 May 2021, para mag-investigate. So itong sa 2021, formal investigation yung nangyari, pero ito pong sa February 2018 was a preliminary examination lang. Okay? And then pupunta po tayo niyan ngayon sa defense. So, yung main defense po talaga na ginamit dito nila Attorney Kaufman is that yung ano daw po, yung nangyari nung preliminary examination is not an actual consideration of the court pa nila dun sa kaso or sa situation in the Republic of the Philippines. Okay, yung main argument po nila na exercise daw po yung jurisdiction lang ng ICC noong 2021 kung saan nagkaroon na po ng formal investigation na request yung prosecutor at ginrant po ng pretrial chamber. Okay, and then yung prosecution naman po, yung counter argument nila dun, nag-start daw yung paghawak ng ICC or pag-exercise po ng ICC ng jurisdiction sa kaso ni Fprrd noong 2018 pa kung saan nag-start po yung preliminary examination. Okay, so yan po yung main defense and main arguments ng both the defense and the prosecution. And ngayon naman po, pag-usapan natin yung actual reasons ng ICC as to why they rejected po the challenge to jurisdiction nila Fprrd. Okay, so unang-una po, i-take note nyo lang, ito pong lahat ng sinasabi ko is not from my own legal opinion or legal point of view. Ang sasabihin ko lang po at i-explain sa inyong lahat ngayon ay galing mismo sa ICC, itong nasa loob po ng decision nila. And para po mas mapadali nyo maintindihan itong discussion natin, kasi medyo mahaba po to, 32 pages to siya, ang gagawin ko na lang po, magbibigay ako ng summary based on everything dito na binasa ko po sa ICC decision. So I read all of this, hindi ko lang na nilagyan ng highlights yung iba na hindi naman important. So again, ulitin ko lang po, hindi ko po to point of view. This is the decision po from the ICC itself, and I am simply reading the decision of the ICC para maintindihan nyo yung rason kung bakit ni-reject nila yung defense, yung challenge to jurisdiction defense ni Fprrd. Okay? So dito po makita ninyo, again, inulit po ng ICC pretrial chamber na yung preliminary examination daw po ng prosecutor dun sa Philippine situation was on February 8, 2018, and then the government of the Philippines deposited the withdrawal only on March 17, 2018, and then which took effect on March 17, 2019. Tapos yung conclusion po na binigay ng ICC, the Philippines was therefore a state party to the statute and was bound by its provisions from 1 November 2011 to 16 March 2019. So in other words po, hindi tinanggap ng ICC dito yung argument ni Attorney Kaufman na nag-start lang yung exercise ng jurisdiction ng pretrial chamber on the year 2021. Okay? As per the ICC, yung pinaka-start daw po is nung preliminary examination pa on the date February 8, 2018. Okay? And yung main reason po niya ng ICC kung bakit ganun po yung interpretation nila is because daw po sa wordings na ginamit ng Article 127, Paragraph 2 of the Rome Statute, which is nakalagay po dito, shall not prejudice in any way the continued consideration of any matter which was already under consideration by the court prior to the date on which the withdrawal became effective. Okay, so ito pong any matter, highlight ko po ulit yung second pa para ma-emphasize talaga. Dito daw po pumasok yung preliminary examination kasi ang sinabi daw po ng batas is any matter. Therefore, yung preliminary examination po falls under these wordings of any matter. So yan po yung pinaka main reason talaga ng ICC. And then ngayon, ipakita ko lang po yung counter-argument naman ni Attorney Kaufman dito. So yung counter-argument po ni Attorney Kaufman dun sa preliminary examination is that masyado daw informal yung preliminary examination para pumasok siya dun sa any matter under consideration by the court na wordings daw po ng Rome Statute. Pero ang sinabi po ng ICC dun, the chamber does not accept that the preliminary examination is too informal in nature to encompass a matter that is under consideration. So basically po, inulit-ulit dito ng ICC, although hindi ko na po i-flash kasi mas gugulo pa yung discussion natin. Inulit-ulit po nila at in-emphasize nila na since yung wordings daw po ng batas is very plain and simple na any matter under consideration, therefore it should be interpreted daw po with its literal meaning of under consideration na any matter. So since wala naman daw qualification na ginawa yung batas ng formal or informal, therefore po yung preliminary examination daw, although quote-unquote informal as per Attorney Kaufman, will still fall under the any matter under consideration wordings of the law. Okay, so yan po yung inulit-ulit dito ng ICC. Yan o, under consideration, and then any matter, ordinary meaning. Yan. So since again, wala daw pong qualification, bigyan lang ng ordinary meaning yung terms na any matter and under consideration. Therefore, yung preliminary examination will fall under those definitions ng batas po or ng Rome Statute. Okay? Tapos yung isa pa pong in-emphasize din dito ng ICC pretrial chamber is yung term na by the court. Okay? So in-emphasize po ng ICC dito na yung term daw or yung word na court sa Article 127 paragraph 2 is capitalized. Yan o, malaki yung C. And pag ganyan po kasi in legal jargon or in legal terminologies, pag may nakakapitalize, ibig sabihin po niyan that refers to a specific subject matter. Okay? Which in this case po, ang sabi ng pretrial chamber, klaro daw po yan from Article 1 of the statute, which designates the International Criminal Court as the court. Okay, so the reason kaya to in-emphasize ng ICC or ng pretrial chamber na term na the court na capitalized is because the court is expressly stated daw po to be composed of 4 organs, one of which is the office of the prosecutor. Okay, so kung sa Tagalog pa, yung prosecutor daw po ay kasama sa term na the court, which is yung kabuuang International Criminal Court. Therefore po, nung nag-undergo na ng preliminary examination yung prosecutor, pasok po yun siya sa term na any matter under consideration by the court kasi yung prosecutor po ay kasama sa definition ng the court. Okay, so in other words, pinukpok po talaga na ng pinukpok na may jurisdiction sila yung ICC sa kaso ni Fprrd. Kasi yun nga daw po, nag-start yung exercise of jurisdiction on the year 2018 prior to the withdrawal ng ICC or ng Philippines po sa ICC. Therefore, they have jurisdiction and they exercise their jurisdiction within the periods allowed by the Rome Statute. Yan po yung pinaka-summary talaga ng point dito ng pretrial chamber. So ngayon, ang next question, based on everything na diniscuss ng pretrial chamber, ang dating po mukhang wala na talagang pag-asa, di ba, si Fprrd when it comes to the challenge to jurisdiction defense niya. Parang ganun po yung dating kung titingnan lang natin yung actual reasons dito or wordings used by the pretrial chamber. However po, merong mga paragraphs dito na tinake note ako na kung ako po tatanungin ninyo, yung professional assessment ko is favorable po to kay Fprrd. And when I say favorable po, ibig sabihin na pag iakyat po or i-appeal nila Fprrd sa appeals chamber yung decision na to, may pag-asa pa naman na mabago yung decision. Okay? At yung first po niyan is ito pong nasa paragraph 60, which is nakalagay po dito, the chamber observes that in future situations, it may not be that every preliminary examination would encompass a matter which was already under consideration by the court within the meaning of Article 127.2 of the statute. A finding in this regard is not an automatic exercise and needs to be approached with utmost caution to avoid any abuse. Okay? So kung iintindihin po natin itong statement na to ng pretrial chamber, alam din nila na pag gagamitin daw po lagi na yung preliminary examination pasok lagi dun sa any matter under consideration ng Rome Statute sa 127 paragraph 2, alam din daw po nila that can lead to abuses. So ganito na lang po para mas maintindihan nyo talaga yung point ko dito. In the simplest way I can explain this paragraph po, mukhang alam din ng ICC na basta pag gamitin lang lagi yung preliminary examination sa under any matter na word, it could lead to abuses. Pero ang ginawa lang nila dito sa future situations na daw nila yon i-consider na hindi siya dapat automatic exercise lang ng jurisdiction ng ICC. And the reason po why I am saying that this is favorable to Fprrd because dito nga po it appears that the pretrial chamber themselves, alam nila that this interpretation nila could lead to abuses. So kung i-argue to ngayon nila Attorney Kaufman dun sa appeals chamber tas ma-convince nila Attorney Kaufman na ganito nga, pagbibigyan lang ng ordinary meaning interpretation yung words ng batas, may pag-asa po na ma-overturn yung decision na to. Pero however po, we have to remember, at present, ito yung actual decision na which is rejected pa. Pero pwede pa nga po i-appeal yan like what I discussed in the first video regarding this topic or this subject matter. Okay, so again, this is the first na statement po na mukhang kung ako tatanungin, it could be favorable to Fprrd if used and argued correctly po ni Attorney Kaufman sa appeals chamber. Ngayon naman po may ipapakita rin ako sa inyong isa pa na pwede rin, na mukhang pabor pa rin po kay Fprrd naman. Okay, so ang next ko pong ipapakita sa inyo is in paragraph 10 of the ICC decision. So this one I actually discussed this dun sa first video on this subject matter po, pero i-reiterate ko na lang po siya ulit. So again, on July 18, 2023, may nilabas pong decision yung appeals Chamber at yung decision daw po na yon was not a decision with respect to jurisdiction. Okay, so ang reason po kaya ko to pinapakita sa inyo is because since hindi pa nga dinesisyonan ng Appeals Chamber yung issue on the jurisdiction ng ICC sa kaso ni Fprrd, pag iakyat po to nila Attorney Kaufman, nila Fprrd sa Appeals Chamber, pwede pa rin po to ma-overturn kasi yung dati daw pong decision nga nung July 2023 ay wala pang kinalaman sa jurisdiction. Diba? So I'm just emphasizing this kasi baka po ma-confuse kayo kasi itong decision na to actually may mga shorts, may mga videos, may mga posts regarding this tapos pinapalabas na or it appears po in the eyes of an ordinary person na mukhang jurisdiction na yung pinag-usapan doon ng ICC pero dito po makita natin ni-reiterate ng pre-trial chamber na yung decision na yun ng appeals chamber was not a decision pa with respect to jurisdiction and because of that may pag-asa pa po si Fprrd na mag-iba yung decision na to pag pumabor po sa kanya yung appeals chamber. So in conclusion po dito sa last part natin, ang i-emphasize ko lang po is that yung ICC pre-trial chamber themselves, alam po nila na pag isama lang daw yung term na preliminary examination under dun sa words na any matter under consideration by the court, it could lead to abuses and since ito po wala pang actual decision yung appeals chamber sa jurisdiction issue sa kaso ni Fprrd, therefore may pag-asa pa po na magbago to or mabago po itong decision in relation sa challenge to jurisdiction. Okay, so yan lang po ang gusto ko i-emphasize. Pero again, tandaan po ninyo, at present, talo na yung challenge to jurisdiction ni Fprrd kasi yung current po is the pre-trial chamber decision. Okay, and the only way po para manalo pa si Fprrd ay pag yung appeals chamber ang pumanig sa kanya. Okay, at kung curious po kayo kung ano naman yung sagot sa question na kung ano ngayon yung mangyayari sa kaso ni Fprrd assuming mag-appeal po sila Attorney Kaufman, nandun po yun sa first video ko. So panoorin nyo na lang po dun. Okay, so anyway po, hopefully klaro po itong discussion natin. If you like more legal videos, subscribe lang po kayo sa YouTube channel ko. And until next time po, see you all. Bye-bye!